can a child choose with which parent he or she's going to live? What is the real scoop? What's the truth about the child preference factor when we talk about custody? Well, my name is Akiva Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. So, when we talk about where a child's going to live in a custody battle, there's about a dozen factors or so that the court takes into account, one of which is the expressed preference of the minor child. Now, you know that the court is not going to accept the expressed preference of every child. The court's going to look at the age to determine is the person of suitable age and discretion to even express a preference. A 5-year-old's not going to get to express a preference. A 5-year-old is going to go with whoever offers him or her a shiny lollipop. That's going to be his preference. And the court knows that, so the court's not going to do that. But if the kid is a teenager, let's say, or 12 or 13 years old, the court will listen to the preference. And how does this happen, by the way? The court doesn't make the child testify in open court, thereby putting the child at ease or taking away the child's ease, as the court has to have the child testify, I'd rather live with mom and dad, and that's going to be embarrassing for everybody. So no, the court doesn't put anybody through that. What the court will do is take a break, bring the child into chambers, sit the child down and say, look, I know this is a difficult decision. If you had a choice, if you had to express a preference, would you rather stay with mom or with dad? And if the child expresses a preference, the court will ask, why? Why do you want this? And if the court finds that there's some legitimate reason, the court will take it into account. And if the court finds that the child wants to stay with dad because dad promised the child, a car, or if he stays with dad, the court's going to take that into account also. Not going to be too thrilled about that. But anyway, once the court hears the preference, the court will go back on the record and continue the case and will note that in its ruling that the child has expressed a preference, but that doesn't mean that that's going to carry the day. The truth about that preference is it's just another piece of evidence. It's one out of the dozen factors. There might be 11 other factors that go against what the child wants. The court is receptive to the notion that the child may express a preference for no reason that the court thinks is valid, but rather for reasons of being promised things, or not promised things, but maybe mom is running a police state at home with a lot of structure and rigid rules. Dad is running Disneyland where there are no rules and they stay up until they pass out in front of the TV. So maybe the teenage kid would rather go where there are no rules. Well, that's not necessarily going to be overly persuasive before the court. So is there a preference that can be expressed? Yes. Does it mean it's going to carry the day? Probably not. Remember, the judge is going to listen to that preference and he's going to look to what that preference truly means. And even if he gives weight to it, it doesn't mean he's going to give the same weight to, any of the other factors, like the emotional stability of the child, like the presence of abuse in the household. Those are things that may carry more weight than the expressed preference of the minor child. If you have any questions about your case, reach out. And of course, we'll be glad to help you out.